Well, good morning, good afternoon from the West Coast to the East Coast. I hope everyone is keeping warm. My name is Fred Lotta-Parisa. I'm the president for XM 2020 Group and also a board member for the National Association of District Export Council, also known in its acronym NADEC. NADEC is a volunteer district export council where members are in all 50 states, representing more than 1,500 DEC members appointed by the Secretary of Commerce. This morning, it's my honor to introduce my good friend, our keynote speaker, Tom Cook, a U.S. Marine veteran, managing director of Blue Tiger International, and director of the National Institute for World Trade, and a global trade author. I may add to that, Tom has, to this date, written 21 books on trade related. He's a very well recognized speaker across 50 states who emphasized the critical importance of rigorous trade compliance. That's what we're going to be talking about, in reducing risk, cost, and complexity in international supply chains. A couple of reminders today. We are looking for feedback and interaction, and it's important that we get questions. So please direct that to the chat messages, and Heidi and will address that. But I think it's important, if you have any kind of, don't be shy, just put up that questions, and I think that has worked very well for that. So without further ado, please welcome our keynote speaker, Mr. Tom Cook.
Thank you, Fred. Thank you, Heidi, and thank NADEC for setting up the event. I sit on the board along with Fred on the National Association of District Export Councils. All the members are sitting at local export councils all throughout the United States. And one of the important things in succeeding in global trade is the idea of establishing resources and contacts and having a networking group where you can find out answers to questions and the challenges that come up in everyday international trade. And NADEC is one of the stronger of the resources that are available, because not only do you have a lot of trade specialists that have been operating for 15, 20, 25, 30 years to use as a resource, but you also have a entryway into various government agencies, principally the Department of Commerce, where if we can't find out the answer, then we have resources ourselves internally in the Department of Commerce to get answers. So it's a connection into the government and is really a very, very reliable resource. So as Fred mentioned, Blue Tiger International is the company that I founded and represent. We go back more than 36 years, and we help companies navigate the challenges of global trade. Right now, obviously, tariffs is a very big issue. The mitigation of those tariffs is a big issue that we're heavily involved in. But also, we have a vertical in our company, or a silo, as we refer to it, that specializes in trade compliance, both on import and export activity. Today's conversation is on export trade compliance. And as Fred mentioned about questions and everything, you can put the questions into the chat and we'll answer the questions as they come up. We're not going to wait just to the end. If we make it a little bit more dialogue throughout the discussion points, then I think it'll be a little bit more interesting. The PowerPoint is designed to give me just an idea of the things that I need to talk about and so forth like that. And the PowerPoint will be made available to everybody after the event itself. Okay, so when we look at this whole concept of trade compliance, the issue of its importance is because of the consequences if we don't. It creates an inability to export if we don't do it correctly. It creates delays in shipments that get held up by various government agencies and authorities if documentation or consignee information is incorrect. You obviously are creating a sale to a foreign company that now is being blocked. You're going to have dissatisfied foreign customers and obviously unhappy sales personnel and obviously senior management because revenue is going to be impacted. And once these problems occur in trade compliance, and some can be very serious, even rise to the level of criminal, it creates a significant amount of internal time allocation, which has been unplanned to deal with these issues, ultimately leading to potential fines and penalties, which could be as much as 11 times the value of the transaction. In a lot of cases, you have to hire a specialized trade attorney, which has legal costs involved, particularly for companies that are local in a community or bigger companies that have a public nature, bad press that's associated with the penalty. There are plenty of examples of actually larger public companies losing the value of their share because of particular violations, both on the import and export side. Obviously, there are civil issues to be concerned with and also criminal issues. And lastly, just a tremendous amount of aggravation because you can't get your regular responsibilities done because you're focused on the issue of resolving the trade compliance issue. I'd like to just comment a little bit about exports in general, and then I'm going to come back specifically to compliance, is that U.S. exports have always been and are continually in high demand globally. A lot of that has to do with the product quality. American companies generally provide a very high level quality product. Our technology is top in the world. Our transportation infrastructure for things that we import and export are top in the world. We offer generally the ability to offer favorable payment terms, okay, in the transactions. And lastly, our customer service is second to none in the world. Okay, and a lot of companies, even though they might be able to get it less expensively somewhere else, will come to the United States principally because of the customer service level that they obtain here that they don't get in other countries around the world. And as we all know, for those of us involved in international trade, our president has created a tremendous amount of disruption in the supply chain world, particularly on goods being imported into the United States. One of the rationales of what he's trying to accomplish is to create reciprocity in trade. The best example is to look at if BMW made an automobile in Germany and they manufactured that there, and that now comes into the United States. When it crosses the border, they would pay a 2.5% duty rate on that car coming into the United States. If General Motors wanted to sell a car into Germany, when it crosses the German border, the duty rate would be around 17.5%. And that inequity is almost through all the countries of the world. So Trump has used the term reciprocity or reciprocal tariffs. What his goal is in going aggressively after companies by ramping up their cost of selling goods into the United States by telling them that he'll bring those tariffs back to normalization once they bring their tariffs down so that American products can be much more competitive. And in fact, there are more than 100 countries have come to the Department of Commerce and the president's administration to negotiate for favorable deals. And overall, while a lot of the countries around the world are struggling with their economy, our economy is very strong. Our GDP numbers for the third quarter and the fourth quarter were highly much more than expected, and the expectation for the first quarter is even going to be higher than that. About 100 countries have come to us, and they're in the middle of negotiation, but there are a number of countries that we've already had now negotiations with who have already reacted in lowering their duty rates on products, U.S. products coming into those countries. Mexico, Great Britain, the EU, Vietnam, Malaysia, Indonesia, South Korea, Thailand, Switzerland, Taiwan, El Salvador, Guatemala, and Liechtenstein is just a handful of the countries that have. And there are a number of negotiations still going on with China. Okay, this seems to be an ongoing discussion, Pakistan and the Philippines. And I've just listed some of the countries that I know of the activity that's there, but there's really a much more extended list, okay, that they're working on to bring down those tariffs. So while on the import side, there's a lot of disruption and chaos and uncertainty, on the export side, in fact, the president has opened up a significant amount of opportunities for American companies to sell abroad. And the factor is that the duty rates as entering those countries is lower. So when we have an export, we like to, in our consulting practice, silo it into four different areas when we pick apart things to see where betterments can be made or problems or challenges be resolved. We start off with the Incoterm that's used, the international commercial term, FOB, CIF, TDP, that term. Then you have the logistics of the movement, okay, moving it from point A somewhere in the United States to point B overseas. You have the consignee and the additional parties that are involved in the transaction, from the carriers that's used, the banks that are transferring the money between the parties and so forth. And then lastly, you have an import that's going into the country of sale. And we like to break down these transactions because there's factors that come into play from an export compliance perspective in each one of these areas. And it's very important to silo because you have to take independent actions in order to make sure you're doing the transaction correctly. So we just look at the Incoterm itself. The Incoterm, in the most simplest of definitions, is a point in time where the responsibility and the liability pass between the seller and the buyer, or the exporter and the importer. I'm going to say that again because it's a very important aspect. It's a point in time in trade where the responsibility and liability, cost and risk, pass between the seller and a buyer. So when we talk about risks, part of those risks are making sure that that transaction is compliant with both export regulations out of the United States and import regulations of the country that you're selling to. The Incoterms are established by the ICC, the International Chamber of Commerce in Paris, France. Okay. In the US, United States, we don't recognize those Incoterms independently. Nowhere in federal law will you see Incoterms that's established by the International Chamber of Commerce in Paris, sanctioned by the United Nations. Okay. But in the US, you don't see it in federal law. But in federal law, we have contracts of purchase and contracts of sale with all countries around the world where we have trade agreements. And if an Incoterm is used within those trade agreements, that's where it's acknowledged as having legal precedence, but not as an independent subject. Most people don't realize that. You have to appreciate that if you're selling any product into a foreign country, that there are rules that might be unique to that product. Just if you were shipping something that was a food or a pharmaceutical product or a medicine or a piece of medical equipment, right? Every country around the world has the equivalent of USDAs and FTAs that are going to want things to how they're packaged, marked, labeled, specifications, how they're sold, how they're described, okay, get it approved. The factory where it's made has to be approved by their foreign governments and so forth. So the same thing we have when we sell things all around the world, it applies to things both import and export. We have to look at it that way. And also appreciate that the Incoterm will have an impact on payment. We just had a case come into our office where a company selling to a company in France on an ex works basis. The term Incoterm was ex works, meaning that they're drawing the line in the sand at their loading dock. That's when that point in time of transfer to the buyer. But their payment term was once the goods were received, that they would remit the $500,000 in that commercial transaction. Well, along the way, the vessel hit heavy weather and a number of containers went overboard, those carrying the product for this particular customer. So the company in France took the position that we never received the goods, okay, and therefore we're not going to make payment. Now, obviously, the Incoterm said anything after the loading dock is the responsibility of the company in Paris. So internationally, you have a rule that should be held in place. But the company in Paris said, you know something, if you want to collect your money, you're going to have to sue us. So appreciate that That now takes as much as a year to get paid. You have legal costs involved, and you never know if you're going to get a settlement, and you may never get the full $500,000. So when we have Incoterms from a compliance perspective, we always have to think about how we're getting paid and where there might be risk. From a logistics standpoint, you have a forwarder and a carrier that most companies will use, meaning they'll arrange a transaction with a freight forwarder, and usually a carrier will be used in international. If it's going to Canada or Mexico, it could be truck or rail. If it's going most other places of the world, it's going to be by ocean or air. One of the things I'm going to bring up in a number of slides later is that there's a principle in trade compliance in the United States that the principal importer or exporter has to supervise and control the activity of the freight forwarder. So in an agreement with a freight forwarder, you're giving them power of attorney to interface with the US government on your behalf. Okay. But the federal government says you can give them all the authority that you want, but you still have to supervise and control that, meaning you're still going to be responsible if they make an error in how they cut a shipper's export declaration, or if they ship freight to the wrong place, or they make some mistake along the way that causes you as the exporter certain harm. Appreciate that there's options in transit, cost and time that they help you decide. Ship it by air, ship it by rail, ship it by vessel. Appreciate the fact that there are significant transit risks, okay? Depending upon the statistics that you read from various government agencies, anywhere between 1.5% to 3% of all cargo that transits internationally gets lost or stolen. It's pretty high. We arrange cargo insurance, right? Usually controlled by who has the insurable interest in the transaction, which is another compliance aspect. And lastly, appreciate that your client, depending upon the Incoterm, okay, and how you've structured the transaction, is going to have responsibility most likely for the import into their country. And did they arrange for an import permit, okay, which is a compliance issue? Is this something that they legally can bring into their country? We're handling a case now out of California in which a large cosmetic company shipped something down to Brazil worth close to $750,000, and its formalization is not acceptable to the government agency supervising that material coming into Brazil. And now it's stuck in a holding pattern, okay? And the client in California hasn't been paid for it. The company in Brazil is not going to pay for it because they're never going to be able to see it because it will never be allowed in. And there's problems now in trying to re-export it back to the United States because the authorities just want to destroy it. So it's a big mishmash that's happened. If the company did due diligence, which I'm going to talk about in a few moments, that probably could have been prevented. The consignee and the additional parties involved. We have an obligation, okay, by law, that whenever we enter into a transaction internationally, both on the import and the export side, that we check a denied parties list, which is an accumulation list of 8 different government agencies of companies that we're not allowed to, or there are controls on who we can and cannot trade with. These are individuals and these are companies, okay? And some of those individuals and companies are here in the United States, most are overseas. Okay, when we do audits of export programs for a lot of companies, I would tell you that as many as 30 to 40% of the companies that we see do not have a process in place in checking the denied parties. Okay, it's a huge area of violation, and any export order that would be the first thing they're asking. Explain to us how you check the parties. And the parties is not just the company you're selling it to, but it's any company involved in the transaction, the freight forwarder, the steamship line or the airline, the bank that's moving the money, the clearance agent that's overseas, and the customer themselves. The goods are going through the border that you're exporting to a company overseas. Irrespective of the Incoterm, you want to make sure that your customer has it structured in their import side so that they can receive that product in the condition and the timing that you wanted it to. A lot of countries around the world require import permits, okay, which means that your consignee has to arrange for that permit to come in. If you sold to them DDP, delivered duty paid, then you would have to take on that responsibility. Okay. Ability to pay. Okay. Doing your due diligence to make sure you have that covered. Further export sales. Is the company that you're selling to going to resell those goods to somebody in another country? And are they allowed to do that? I'm going to come back to this subject in a case study that I'm going to talk to you about in a few moments. And appreciate that when you do have an export violation, the government agencies, particularly the Bureau of Industry and Security, okay, they broadcast that. They put that out in news releases, and they use the name of the company and the name of the individuals that are involved. Okay, and if you're a public company, that could be a pretty serious problem, or for your large company or your company that's serving a particular community. We have the import in the country of sale. And you have to appreciate that. Well, your biggest responsibility is to export it, right? To get it there. Okay. You want to have a satisfied customer who actually has successfully moved that shipment through their customs, okay, and received it. So they have the primary responsibilities depending upon the Incoterm that's used. Most countries around the world, as I stated earlier, requires permits and licenses. There are import costs. There's customs clearance charges. There's duties. There could be additional surcharges that are allocated. Okay. And so you can have a number of things where there are additional costs involved. And then the final trip, which is freight, to the final destination. You also have product liability concerns. Another area when we do an audit, we find that a lot of exporters don't realize this, that when you sell something to a goods overseas, okay, you can be held as the manufacturer of record in that country and responsible for any product liability that might be developed on that export sale. And always remember that there's always going to be a delivery to a final destination. So here in the United States, there are several government agencies that are engaged in export controls and trade or have oversight over trade compliance management. The largest agency that's involved, and the one that most exporters interface with, is the Department of Commerce. They have two sets of regulations, the Export Administration Regulations, EAR, which is supervised by the BIS, the Bureau of Industry and Security. Okay. About 80% of what we export is covered under the Department of Commerce. They're specifically designed for goods that are used for commercial purposes, not military purposes, commercial purposes. The Department of State comes into the play, and their facility called ITAR, International Traffic and Arms Regulations, that's designed when something is for military application only. You also have Department of Treasury, which is concerned about the movement of money, and they have the Office of Asset Controls, okay, where a lot of times you see where money is being sanctioned or held against a country or a company overseas, that comes in through OFAC sanctions. You have the Department of Homeland Security, which is where Customs reports into two entities, okay? They report in the Department of Homeland Security, and they also report into Treasury, okay? But there are, within Customs export enforcement offices, okay? These are specially trained custom officers because they're at the gateways. They have the manpower, the capability, the technology, and the resources at these gateways all around the country to supervise export transactions. And a lot of times people get caught just because they do random checking, where they'll pull a box from a transaction and have it opened up and make sure they look at the documentation, and does the documentation coincide with what is in the box. And then when we export from the United States, from a compliance standpoint, depending upon what we export, we have to appreciate that there are other government agencies that we have to contend with. Okay, food products have to be confirmed for export from the USDA. Medical products, as an example, or anything covered under the FDA as an import, or sold domestically in the United States has to be viewed the same way in an export transaction. Alcohol, tobacco, and firearms, selling of alcoholic beverages, as an example. The Consumer Protection Commission becomes involved as well. So it's not just on the import side that we have to be concerned with these agencies. We have to be concerned with the U.S. entities for exporting these things and to determine whether or not they have certain regulatory controls that we have in place. And then we have to be concerned on the import side, okay, who we're selling it to, their equivalent agencies, what they need. And packing, marking, labeling issues, ingredient issues, and so forth like that is looked at by the U.S. government one way, and it could be looked at the French government another way. It could be looked by the Chinese government in another way. So you always have to make sure that in your procedures that you set up for your export sales, that you have things that address U.S. controls and things that represent the controls of the countries that you sell to. If you sell to 30 countries around the world, then you might have 30 different sets of SOPs because there might be differences in different places that you sell to. So compliance from the US government perspective comes down to that they want 5 questions answered successfully using common sense and its application to laws that govern specific transactional activity of what we can and what we can't sell. And those 5 questions that they want asked is, what are we exporting? What's the quantity and the value? To what country is it going to? To what consignee in that country is it going to? And what are they going to do with that sale of that merchandise? So if you just take a company that makes guns, let's just take Smith & Wesson as an example, and they're going to sell a gun overseas, you can appreciate that as a weapon. There are certain controls on it, both on the selling side from the US and potentially from the receiving side overseas. If we sell one handgun, not too many people are going to be concerned about one handgun. So quantity and value, if we're now going to sell 250 handguns to the consignee overseas, well, from 1 to 250 changes the nature of that transaction because you can arm a small militia with 250 handguns. So the common sense view of this is that would raise the level of concern that we have, and which means we have to apply due diligence to a higher extent once the quantity and the value increases dramatically. To what country? Well, those handguns that Smith & Wesson is selling it to South Africa. Well, South Africa is a good trading partner with the United States, but there are clandestine activities that occur, like in most countries, and that might raise the concern as compared to it's going to Great Britain, where we have more established relationships and more established controls, and a government that aligns more closely with US regulations. So shipping it to the UK might be looked at differently than shipping it to South Africa. If it's going to a country in the Middle East, that might raise a little bit more concern as well. So to what country plays a role? Who's the consignee, right? This becomes a major issue as well. Is the consignee on the denied parties list? Is there any sanctions against them? Is there any track record that we need to be concerned with? Okay. So identifying the consignee becomes a critical issue. And the last question is for what purpose are they going to use it? If Smith & Wesson, as an example, is going to sell the goods to a agency in Colombia, and it turns out that that's a drug task force that's working with the United Nations and the United States in trying to alleviate the flow of drugs from Colombia into the United States. And the purpose is it's going to arm their enforcement officers. Well, that has a common sense to it. And if that can be validated, that could be a sale that could go through. And appreciate that companies that export, sometimes we have to go to the government and get an export license from either the Department of State, Department of Commerce, or Department of Treasury. And depending upon how these questions get answered, okay, would decide whether or not we have to. And while there's a skill set in this issue, it's also experience. Okay, the people who are more experienced know how to interpret these things much better.
Tom, there are a few questions in the chat. Would it be okay
Okay, let's take them.
to take some? Okay. The first one is we have from Linda Lashendock. We have an Indian customer who is asking us not to include the DG quantity in each box on the commercial invoice and IMO. Can we eliminate the interior box quantity of the DG box and be compliant? Or do I need to include the units within the DG box?
From the U.S. perspective, for it to leave the United States and dealing with the carrier, who's also going to look at that documentation to make sure that they secure that freight in the right place and stow it correctly, all the handling parties involved there, from the United States, they would want to know that information. If the customer is requiring a different document for their import side, if you have an affirmation from them that they're doing this compliantly, you can create a second set of documents and send that ahead of the transaction that they would use in their own country, as long as you have an affirmation that they are telling you they're doing it compliantly. Okay. And in this case, you're now going to use U.S. regulations to export those goods from the United States to make sure that you're in compliance. And you would need that detail in the documentation for that product.
Okay.
Next question.
Yes, from Julie Detmering. She has a shipment going to Indonesia, and at the last minute, the customer asked us to ship it to Singapore first to get the survey report done. Survey report in quotes. This sounds suspicious to me. Is this legitimate? Where can I go to find the country-specific regulations that change rapidly?
If you let her on mute, I need to ask a couple of questions to answer it. So if she wants to unmute, or you can unmute her, let me know when that happens.
Gotta find her in the list here. There you are. Okay, Julie, you can talk.
Julie, what's the product?
Here.
Julie, what's the product?
The product is a pressure regulator.
Pressure regulator.
Yes,
Your
sir.
knowledge, is that controlled by the U.S. government?
It is. It's a 2B 999 product,
Right.
and it's going to Indonesia. The purchase order all showed an address to Indonesia, and then the day before we shipped it, when the snow hit, they sent an email asking us to send it to a Singapore address for a survey to be done. And at that point, it was too late because it was already going. And like, this is the first we've heard of this address or any of that request.
When they say survey, I'm trying to understand. They were trying to do like a quality control check. Is that what they're looking
that
at?
I don't understand either. I tried to Google it, and it said it was supplementary document required during customs clearance, specifically with Indonesia.
You got a red flag there. Okay.
Thank
Absolutely.
you. Okay, I wanted to make sure I was correct.
Right. What was your Incoterm of sale? What was the Incoterm?
It was DAP.
Okay, so you're just delivering it to a place in Indonesia, typically the gateway coming in, correct? Or are you giving
We
an
were actually
address?
going door to door because it's a small
Okay.
package.
And they have the responsibility for customs clearance.
Correct.
Right. I think you just leave it as it is, that it's going to go to them directly. Yeah, I would send to them in forward of the shipment the documentation that you've created, so that if they need anything else to be able to clear those goods, that they can ask you for it. But I would not would not go through another country in this.
Excellent. Thank you. I thought that was the case. I wanted to make sure.
Right. Red flags, I mean, they're all over the place, and that's one of them.
Excellent. Appreciate it.
No problem.
Okay.
And we have another question, Heidi?
Another question. Here's one. A to Z Logistics sends a third-party driver to pick up and deliver to the airport. Do we need to screen the third-party driver as well? I've done that in the past, but not all companies do this.
If your product is not controlled, I would not be overly concerned about screening the driver. If you were shipping handguns or you were shipping, sensitive equipment that might be used by the military, or something that had an export commodity control number attached to it, I would be concerned about that. But if you're talking about a vanilla product, it's not untypical that a freight forwarder will has relationships with these independent truckers to make their pickups and drops at the airport or the terminal. So it's a process that a lot of forwarders will use, and they use a third party. I wouldn't be concerned unless you have something that's highly controlled by the U.S. government. That to me would be a potential red flag.
Okay. All right. Amaf Bashmaf asked, we are seeing a massive push for ESG and sustainability reporting in Singapore and Asia. Is the Export Council seeing new enforcement initiatives targeting the green claims made by exporters?
It's an issue that's raised its ugly head, particularly since our president has gone so aggressively around the world, creating this chaos and uncertainty in trade. And to me, in the last year, this whole issue of sustainability related to green issues has been diminished in most places. They're more concerned about just trying to get the trade organized and the tariff level organized and an agreement in place, more focused rather than on the green issues and sustainability issues. But I think it's going to come back once this all settles out. And when will it settle out? That remains to be seen. Our president continually uses tariffs to negotiate international trade, and I don't think that's going to end real soon, his ability to do that. But to answer the question, we're seeing a lot of it, and you have to pay attention to it. But I think you can probably consider minimizing what I'd call your diligence about it, because we're seeing less and less concern about it. And the only other thing I would add into this conversation is that Europe, the EU, has now put in controls on imports on carbonization levels, the CO2 levels that are used in the manufacturing of the product that are utilized and so forth. So you have to make statements on various documents what the CO2 emissions levels are. And we're seeing some, not so much enforcement as information flow, that they're going to start to control U.S. products coming in and products from all over the world coming into the EU, where CO2 emissions is going to be a factor.
Okay. And the last one for right now is, we export to India. How are we to stay abreast of the Indian regulations when they're not published in a timely manner? Any recommendations?
Most companies use freight forwarders. The last time a survey was done on this was probably about 5 years ago, 6 years ago, and somewhere in the neighborhood of like 96% of exporters use an intermediary company for their exports. That intermediary company that you're using, the freight forwarder using, part of your criteria in using that forwarder is their ability to help you be compliant, meaning that they have to be compliant, but they also have the ability to help you become compliant. And one of the things on sales that go all around the world is that they either have offices overseas, some of the big forwarders likely to have offices, but the smaller, medium-sized forwarders has an agency structure around the world where they have agents who represent them in the various countries. So India is a quagmire all by itself. It's growing dramatically. There's a lot of shift of manufacturing from China into India. Okay. And because they're doing a tremendous amount of manufacturing, they're also doing a tremendous amount of importing of components, parts, raw materials, and the things that they need to manufacture. And so, in order to stay abreast, you need to have a forwarder who has an agent there, okay, who can come back to you with the information that you need in your transactions with that country, keeping you abreast. Okay. Um, that would be the first source. The second source is that you can reach into the Department of Commerce. Department of Commerce actually has the Commercial Service. Commercial Service has an India desk in Washington that you can reach to, and you can ask certain information from that desk. You can reach into NADEC, okay, if you have a question like that, and we would be responsive to you, okay. And also, I think reading literature such as the Journal of Commerce is a great magazine, American Shipper, a Global Trade magazine, another thing, Inbound Logistics is another one. You've got to have a lot of resources coming into you because things, one thing might miss something, but you'll see it picked up in another publication and so forth. So the accumulation of those resources, but the primary one is using a forwarder who has a contact, an office, an agent in India, and is coming back to you with the information you need regarding your product and to who you're selling it to.
Okay, yeah. And yes, those resources, we'll repeat those. I'll send you those out in a follow-up email. But we
Right.
should
And my contact information is on this slide deck and so forth. You can always reach out to me directly, and I will write up for you some of the things that you would want to know about. Okay.
Okay.
If we
All
take those 5 questions and looked at the BIS regulations specifically, they put it into their own language here, but they have it 3 questions rather than 5. But we know practically 5 is better. The ECCN number, the Export Commodity Control Number, is what the item is from a federal government perspective. Its end use is what it will do. That's, the functionality of it. Okay. And last is end user, who gets it, right? That's the consignee, as I mentioned in the other thing. So they just look at it worded a little bit differently. My other slide previously looks at it more practically. Okay. In trade compliance, okay, the expectation, and this relates to both imports and exports and all governing agencies that have to do with international trade, import and export, they have 3 very overriding principles when they come in to do an audit or an assessment, or if they come in after you, what their expectation is that you, as that exporter, are managing your export transactions with due diligence, reasonable care, and supervision and control. Those 3 things, what it means is due diligence and reasonable care means that you understand what the regulations are and you're applying those regulations, okay, in your operation, okay? And that's best achieved by creating procedures, written procedures, okay, that follow the guidelines of the federal government. The BIS actually on their website shows you how to even create those procedures. And you're also welcome to reach into me, and I'd be happy to show you how that can be done. I'm going to talk a little bit about it in a moment. Supervision and control, I mentioned this earlier, but it's important to reiterate it, that most companies will use a freight forwarder, custom-asked broker, okay? Use a third party. If you ship directly using FedEx and UPS, they're considered the service provider and the carrier, okay? You have to supervise and control their activity, even though they might be considered the experts in what they do. Government requires that you to at least be able to supervise and control their activity. Years ago, importers, exporters got in trouble. They'd say, hey, the forwarder told me that, or the broker told me that, or the carrier told me that. So in 1993, the government changed how these regulations were done, and they updated it in 2003 that you have to be able to supervise and control the activity of the forwarders and brokers that you use, and you can't hide behind them as an excuse if something goes wrong. And the last one is one that we've added based upon our experience and appreciate. We've been doing this as a team for more than 36 years, is they also have an expectation, because I've sat in a number of audits, of proactive engagement. I've seen them ask across the conference table to the export manager or to the customer service manager or to the CEO of a company, how do you keep yourself aligned with the regulatory changes as they are occurring? How are you made aware of what you need to know? And the term we use is proactive engagement. And attending an event like this is proactive engagement. And appreciate that the BIS, the State Department, and Treasury have several times a year outreach initiatives that they put out there in different parts around the country where they send out their offices to explain how they operate, how they think, and answer questions from a regulatory standpoint. And NADEC, such as this seminar, goes into this kind of in detail as well. This is considered proactive engagement. Okay, couple of other more detailed points. The US PPI. Back just after the events of 9/11, the Department of Commerce and other government agencies made a decision to define what an exporter was, because apparently with so many parties in a transaction, who actually is the exporter sometimes was not clear. So the government came up with the guideline, United States Principal Party in Interest. And the basic definition of it is it's the party that really receives the primary financial benefit for the export transaction. And that's the party who is the exporter. So that doesn't work well with Incoterms, because Incoterms in each one of the 11 terms says to you who is responsible for compliance. Okay. The US PPI rule overrules Incoterms and says we don't care what Incoterm you use. If you receive the primary financial benefit for that export transaction, then you're the responsible party to answer those 5 questions. Where those goods actually end up and what they're being used for becomes your problem. So if a manufacturer sells it to a third party in the United States who then exports the goods out, okay, and the third party is getting 10% for that transaction, the principal company is getting 90%, that manufacturer is going to be responsible for export compliance, okay? And we get probably 7, 8, 10 cases a year come into our office where a manufacturer gets a call from the Bureau of Industry Security, and they're saying, but we weren't the exporter, and the government's saying, yes, you are, okay? And now they realize they have an issue. Denied parties list, I mentioned that before. It's a list that we have to check. It's from 8 different agencies, okay? There's a portal going through into the government. You go to the Department of Commerce website, doc.gov, and you can get connected right into that. And you can actually download it into your system, or you create a live portal connection. The EAR works for the Department of Commerce. ITAR works for the Department of State. But you could have a situation where a product can be both sold to the military and also for commercial use. ITAR is only for military utilization. EAR covers things used commercially and also things used commercially that also can be used for military purposes. Okay. If you're unsure, you can reach out to either one of the agencies. They have toll-free numbers and also email drop address that you can use as well. Ask a question. They come back reasonably quickly. Exports or imports, always remember that you're exporting something, but it becomes an import over the country that you're selling to. So you have to be concerned about those documentation requirements as well as regulations. Documentation is the engine of global trade. The quality of documentation moves the shipments through the process. If documentation is done incorrectly, it doesn't make a difference what else you've done right. That could create a problem, a delay, or a fine or a penalty. Okay. And appreciate that trade and treaties that we've had with all these countries around the world are changing now daily because of what our president is doing in trying to create these reciprocal tariffs. So not only you can't rest on the laurels of what was in place in January of last year, you have to be concerned with what's happening in the past month in the countries that you sell to. Department of Commerce is a great resource. tying into their website, their daily communications. CBP tying into their website and their daily communications can keep you up, as well as, again, working with a quality freight forwarder who is tracking and following these things and can help you guide your transactions the right way. Deemed exports. Deemed exports are where we're not necessarily selling a product, but we're selling something that's more intangible. It might be a capability. It might be technology. It might be a service. Okay. It might be training. Okay. And a deemed export is as controlled as a product sale. Okay. We had a case in North Carolina a number of years ago where a company had a welding technology for titanium, which was controlled for export. They had a gentleman come from India to learn how to do that process and bring it back to India to use it in one of their facilities. When that gentleman came through U.S. Customs for coming into the country and asked why he was coming in, he explained he was getting training at this company. The customs officer did a little bit of checking and realized that he was now going to be involved in creating a deemed export, and prevented that gentleman from entering the United States, because anything that he would have learned and took it out of the country as knowledge would be considered a deemed export. Exports from U.S. foreign subsidiaries are controlled by U.S. export regulations. So if you're a company and you have a subsidiary in Barcelona, Spain, and the United States is restricted on selling goods into Iran or Sudan or North Korea, you can't turn around and sell those things from your Spanish subsidiary into that part of the world if it's owned by the a U.S. entity. Transshipping is a huge issue, and the question that came in earlier on our call here was that the importer in Indonesia wanted them to transship through Singapore. Okay, that's a big red flag to anybody in the government when they look at transactions, because when things get transshipped, that's when documentation be changed and they move to places where there's clandestine activities. The ultimate consignee. Okay, this is a big issue. I'm going to give you a case study where ultimate consignee becomes an issue. If you're selling to a company, let's just say in France, and that company is a trading company, well, they're not using the product, they're reselling it. So where they're reselling it to becomes an issue for you. Okay, so ultimate consignee becomes an important aspect when we're having export programs. Getting paid, what I mentioned earlier, you need to make sure that all your ducks are lined up from a documentary standpoint, the flow of the Incoterm that you utilize and so forth, to not have an exposure on getting paid, which relates directly to the choice of Incoterm. Choice of Incoterm should not be randomly done. It should be well thought out, and appreciate it has two parameters. It's a point in time where risk and cost move from the seller to the buyer. Risk and cost, okay? Risk being the key issue. You want to make sure your Incoterm is being utilized where you have minimal risk. Additional export concerns, proper utilization of the Incoterms, responsibilities as the USPPI, EEI, that's the shipper's export tech, filing responsibilities, anything of $2,500 more of value, you have to create that EEI transaction. And user certifications, there are many times in which the government will require that they want an affirmation from the buyer overseas what they're going to do with the product that you're selling. These fall into areas where the product might be controlled for export. Export documentation, responsibilities and accuracy. Documentation done incorrectly, you'll have a problem with that movement. Destination control statements is a should or a have. Shoulds are things that you're likely to do. The have means you have to have it. Destination control statement is something you can put on your commercial invoice and packing list. And we look at it as a best practice that says these shipments are destined for our client in Great Britain. Shipping out of Great Britain is against our guidelines. Okay, so you're putting in a statement that's saying these are for sale for this client in India, or this client in France, or this client in the UK, and further shipping or transshipping to another country is not allowed. Okay, helps you control your relationship to your customer, that they can't do it without coming back to you. You have to look at valuation and transfer pricing, particularly with related parties. It's a big issue for companies that import. It's also a big issue for companies that export to their subsidiaries or their parent companies that are overseas. USMCA qualification, when we sell things to get the benefit under the USMCA agreement, this becomes an issue that we have to make sure it qualifies for USMCA. And as a side note here, most of our team believes that by the end of 2026, we will not have a USMCA agreement. All the information we're getting from the president, his administration, and Department of Commerce is that the USMCA is at risk of being disqualified, and he'll arrange a separate deal with Canada and a separate deal with Mexico. Having regular control reviews and audits is a critical issue that you want to have. Incoterms, as I mentioned before, two terms we do not like on exports is Ex Works and DDP. We don't like Ex Works because you don't have any control over the shipping side of the transaction. Where those goods end up, you really don't know. Okay, so you're going to be held responsible for something you're not controlling. Okay, DDP, delivered duty paid, means you have to bring it to the country you're shipping it to, customs clear it, and then deliver it to your customer. That's a lot of risk in that, because you're now dealing with customs in a foreign country. Don't speak the same language, different time zone, their regulations. Are you aware of what they allow or don't allow, and so forth? So it's just a risky thing to do. There are sometimes you need to do it. Okay, that's when you have a good forwarder who has an agent there who protects your interest. Our preferred terms are CIP, cost insurance paid to, or CPT, cost paid to. Those are preferred terms because you bring it to the inbound gateway of the country that you're shipping it to, okay? And you allow your customer to handle the customs clearance. But you can evidence to the U.S. government by having a copy of the bill of lading showing that you shipped it to the country that you set it up for, to the consignee that you set it up for, where you did all your screening and checking. It's a great method. So Baltimore exporter of navigation equipment have changed the names and some of the circumstances to protect the parties. But this company in Baltimore sold navigation equipment to the UAE. When Israel went to war with the Hamas in Palestine, an Israeli Defense Force team found some of this equipment that was with Hamas that was actually U.S. product, okay? This navigation equipment had to do with GPS, okay? And they brought it to the attention of the U.S. Army, who then sent it to Washington, and eventually went to Department of Commerce and Department of State, who did an investigation. And when they investigated, the Baltimore exporter was asked, who did you sell this to? And they sold it to an entity in the UAE, okay? So now the Department of Commerce, Department of State looked up this UAE, and this UAE company was a trading company. They were never going to use this equipment. They were going to resell it. So the question came back to the supplier in Baltimore: what level of due diligence and reasonable care did you use in making sure that something that is controlled for export, navigation equipment is controlled for export, okay, that to make sure that the entity in the UAE was going to use this product, or if they were a trading company, who they were going to sell it to, which they didn't. The company in the UAE said, listen, this is what we want. We'll pay you in advance. Here's who you're going to ship it to, and so forth. So this ended up in a huge fine exceeding $100,000 to this company in Baltimore, and they lost their privileges of selling the product to certain countries for 3 years. Another case, Seattle-based exporter of specialized petroleum lubricants. This company sold to a company in South Africa, okay? And this product would have an ECCN number under control, but to the company that it was selling it to in South Africa, there wasn't any controls put in place. It had a track record of sales to that country. But in fact, it turned out, and through an investigation that was done through the Bureau of Industry Security operatives in Africa, that this company was selling these products to a number of different entities, some of them military units in various African countries, which was a violation of U.S. export law. Okay, that particular case is relatively new, and it hasn't been finalized like that. But our guidance has said that they're probably going to lose their entire export privileges for 3 years, and a fine probably in the neighborhood of about $200,000 to $250,000. And forget about what their legal expenses are. Legal expenses are probably more than $100,000 by the time that they're done. Trade attorneys are very costly. Export enforcement, EEI filing, you need to have it with every transaction, $2,500 and above. We don't need it for shipments to Canada.
We are at the hour. Would you like to take more questions now, or?
Sure, go right ahead. We're almost done.
All right.
And Heidi, I'd like to add something that I missed. So go ahead and finish that, but I would like to summarize something that I missed during the introduction. Thank you.
Okay, sure. First one is proof of delivery. What do you say when someone in a leadership role says, I've worked for this company for 40 plus years and we have never obtained POD?
The answer is that you've been lucky for 40 years. Good luck doesn't replace good management. Good management, you should have been doing it for the last 40 years. Because
Okay.
there are transactions that need a POD by law, and it's a best practice as a general statement. How do you answer the question? How do you know the goods got to the consignee you intended for shipping? Right?
Yeah.
The only way you're going to be able to answer that is if you have a proof of delivery.
Very good. Yes. Second, if I sell aftermarket parts and components to a distributor overseas and they resell it, how do I confirm who is the end user?
You can ask them, and you can do this in arrears. You can say to them at each quarter, you want a list of the companies that they've sold it to. And then you can do a checking of those companies against the 9 parties list to see if, in fact, there was a sale that was to a party that was under U.S. control. Okay. And you can then report that to the government in arrears, because they're going to look at the fact that you have that system in place. And obviously, you're not going to sell, you're going to put that restriction on your reseller that they can't sell to this entity. That's the general way we go with it. But you can, if you wanted to, if you have something that is highly controllable, you might say to the reseller that you need to identify to us who you're selling it to before you make that transaction, and we're going to check it against the denied parties list before you do. And you can sign an NDA with that party so that they can share with you who they're selling to, and you make a promise that you will not go to them directly. You'll honor that arrangement.
Okay. Next, we sell Ex-Works to our Latin American distributor's U.S. branch, and their freight forwarder handles all of the exporting into Mexico. We are not the exporter of record. Might we still be considered the exporter in the eyes of BIS or other entities?
Yes, because you're probably still going to get the primary financial benefit for it. And there are a lot of times you have to accommodate a customer's requirements if they want to use their party to take the goods at the border and bring it in. But what you can ask for in that transaction, and it has to be arranged at the time of the sale, that you want a copy of the bill of lading to the end customer, okay, showing that the goods actually went to a legitimate party. And that's a reasonable expectation, a reasonable request.
Okay. Mariah Ford asks, I recently changed our Ex-Works Incoterms to FCA because of us having control of the AES filings. BIS 711 is part of due diligence for end user. Is this okay?
Yes. Yes, that's using good sense there. And appreciate that FCA can be used for all modes of transit, where FOB can only be used for ocean freight. So FC is a preferred term, and you want to make sure that you also get a copy of the bill of lading that's showing the shipment out of the United States to the customer overseas.
All right, last one. Are product warranties considered deemed exports? Do they require an HTS code and a country of origin on a commercial invoice?
No, no,
Okay.
no, they're not. There's other aspects of control over it, but not relative to it as a deemed export.
Okay. All right, that's it from the question.
All right, let me add something on it on behalf of NADAC, and thank you, Tom. Very informative information. But I want to add something that that I missed on that. Tom has mentioned Department of Commerce, U.S. Department of Commerce. They are a key entity of the National District Export Council. In particular, is the U.S. and foreign commercial service men and women. They have offices in both the U.S. and overseas. So get your pen ready, and this is a very great resource. It's www.trade.gov. www.trade.gov. That's the U.S. Department of Commerce International Trade Administration. And you will get a lot of support and a lot of resource on it. And they are a key partner of us, of both Tom and myself, and of course, the National District Export Council. So with that, I could also add, and Heidi will mention that again, please complete the survey. That's also very important. And stay tuned, because we are going to continue to provide these type of series in support of U.S. exporters and others on behalf of NAGAC. And thank you again for attending. Thank you again, Tom, for your insight on trade. And please stay warm for those that are on the East Coast, and be safe.
Yes, thank you so much. And I'll be sending out all the follow-up information within 48 hours.
And if any of you have any additional questions, you're welcome to reach into me. My information is on the first and last slide. And if there's anything that we haven't gotten to that's in the slides and you need edification, feel free to reach in. We'll be more than happy to help.
Thank you. All right. Have a good day.